That's a problem.
If not, I've got I could bring it in.
Technical difficulty.
It's gonna be that or Moana. What can I say?
We're live.
Perfect.
Sean, just so you know, we're live and everybody can hear us now. It is 12 o'clock.
Should I sing louder?
Yeah. John's been busy doing his warm-up exercises, so I think he's ready to go. Good afternoon, everyone. Here coming to you from the Kelly Santini webinar studio in downtown Ottawa, otherwise known as Signing Room 3 the rest of the year. Thank you very much for joining us. We have a nice crowd with us, mainly from Ontario, to a few other people who are joining us from across the country. Delighted you are able to join us. My name is going to moderate today's session. I'm the Director of Client Services at Kelly Santini, and this seminar is being presented by the Insurance Group, and our two presenters are here and raring to go. But before I turn things over to them, just a couple of first off, we're going to have a couple of polls during today's webinar. So if you on your dialog box, you will have the access just using your keyboard or mouse to answer some of these survey questions as we go through the seminar, the webinar. We also have a Q&A session sometime at the end of the program. So if you have questions as they come up, again, just using the dialog box, send them in. We'll address as many as we can towards the end. There should be a copy of today's slide presentation available for you to download as well. And that, I think, covers the basics of what we need to go over right now. So let me see if technology works perfectly. So far, so good, I think. Our presenters today, as I mentioned, are both with the Insurance Defense Group. They practice exclusively in this area, covering most of the main areas you would expect in insurance defense, and also as associates in the group also have extensive trial experience, something increasingly rare these days. So we're grateful to have them here, sharing their thoughts and expertise on running a cost-effective defense file. So I will now turn things over and leave it to Sean and Jennifer to take you through the program.
Thanks, Keith. We're going to cover off a few things today. We're going to start with the procedures and steps in a lawsuit, both civil actions and small claims actions, and how to manage your costs throughout those actions. And then we'll talk a bit about some of the kind of types of files we get, being defense files and subrogation files. So let's just jump right in.
So we're going to begin. Survey question number 1. What's a statement of what percentage of cases do you settle before sending a file to counsel?
All right, I'm going to launch the poll right now. You should see it up on your screen. 0 to 10%, 11 to 25, 25 to 50, 51 to 75, or 70. And thank you very much. We see the answers coming in.
And clearly a main driver of this will be corporate policy, along with the reasonableness of plaintiff's counsel on the other side and how much information they can give and provide to you.
And also how much they're willing to work with you. Sometimes I think there's an assumption that you'll just send it off to defense counsel, and so you may not get perhaps as much information as you would like in the beginning stages. That doesn't mean you shouldn't try.
All right, we have just about everybody's voted now, so let's close the poll and we'll share those results. So
what?
One third with between 26 and 50%.
And it's hard to think of a more cost-effective litigation matter than one that doesn't necessarily go all the way to litigation. So the opportunity to resolve early on is fantastic, and especially when the plaintiff's counsel can provide you with relevant information in a personal injury case that may be the medical information, and a building property loss likely to be the damages for monies paid or cost of repairs.
All right, let's get back to our slides. There we go.
So today we're going to talk about the procedures and steps in a lawsuit first, and contrast civil action to small claims action. We'll briefly touch on some of the finer points of these steps as well for those of you that are relatively new to the work, just so that we could stress what we find are some of the important matters in the proceeding. And to begin with civil actions, the primary steps that we go through in chronological order are gathering the necessary information, and that would include documents, videos, all relevant information to the file, the pleading stage, the claim and the defense, the affidavit of documents or documentary discovery, the examinations for discovery, or depositions as they're sometimes known, pre-trial, which is mandatory in the Ontario court, and the trial itself. And we like to say begin with the end in mind. And one of the themes you'll hear from us today is beginning with the outset, understanding that this case could go to trial and preparing for it to go to trial, rather than commencing the action with the expectation. Two reasons for that. Number one is we've done quite a few trials in the last few years where it's been apparent that the other side did not expect to go to trial. And the net result of that is they're profoundly unprepared leading up to and often at trial as well. The other element of it is the amount of preparation that we go into in preparing for trial right from the outset puts us in the right mindset to make sure we don't have any unanswered questions or gaps. And oftentimes that leads to a better resolution because we're able to understand the case at least as well and hopefully better than the other side and even their client.
For small claims, there's a lot of similar elements, but there's also a few different elements. So the gathering information and the pleading stage are, I think, both the same in both civil actions and small claims actions. Just, some helpful things that I find useful when I get my files from the adjusters. Receiving a statement from the insured is really helpful to us, and it's also something we would recommend you do at the outset because, memories are better when events first take place and months or years later. You would be in the best positions to get that statement from your insureds at the time of your own investigation, shortly after the date of loss. Another thing I like gives me a good sense of the file of what occurred at least before we get involved are the notes, the adjuster's notes. It's something I've been seeing more and more, and I take the time to read them and get a sense of, what's been going on, how is plaintiff counsel dealing with things, and it really just gets us, up to speed on everything. The next step for small claims is compilation of the witnesses. Unfortunately, we don't have examinations for discovery in small claims, which can be sometimes not the best because you don't always know what you're kind of expecting at trial. So from an early stage, it's good to know who the witnesses are and getting will-say statements from them to get a sense of what we can expect at trial. It will put us in a better position towards to try to resolve the file or go forward. Settlement conferences, I call them they're similar to a mediation, just with the deputy judge as really the mediator. And it's really one of the only times in a small claims court action that you are able to meet and speak confidentially with the parties and try to resolve the matter. So this is a step that I think should really be focused on in small claims matters, and I think sometimes it's overlooked, and people, in the past I've been in there and it's been 5 minutes, the conference has started and we leave because no one's willing to talk settlement. But I think it's definitely something worth spending some time on being prepared for before going to see if you can resolve the file. And in Ottawa, we have what's called a trial management conference, which will take place after the settlement conference, only if the action is set down for a trial of 1.5 days or more. Unfortunately, in my experience, that's something that's more common now. Small claims trials are becoming extremely complex, and I did a trial that was 4 days long a few weeks ago. So the legal fees that can add up in small claims in comparison to what's being claimed is I think quite troublesome. So settlement in these types of files, I think, is always encouraged if you can.
And with respect to timelines, we often get asked what sort of timelines do we expect. Two answers I'd give. Number one, the shorter the better. Time is money. And in our experience, the longer any case drags on, the more it costs invariably, especially if there's court intervention. But unfortunately, under the current regime, it's difficult to predict how long it's going to take. So, for example, we were at a pre-trial earlier this month for a case that is set down. Expert reports have been exchanged. The matter is ready to go to trial, and the earliest trial date we could get was March 2020. So in the next couple of years, we will be quite literally doing nothing on the file. And a lot of this is Jordan fallout. If you're familiar with the Supreme Court of Canada case in R.V. Jordan, that's the case that determined criminal matters must go to trial within 3 years of person being arrested and put into custody. That is having a fallout effect. One judge candidly informed us at a recent litigation conference that criminal in custody and criminal out of custody cases are the two top priorities for every courthouse in Ontario, followed by family cases dealing with children, and then family cases with agreed upon custody. And a very distant fifth place are what they consider insurance disputes, even though they're not supposed to consider that, but they are aware that most civil actions or commercial actions do involve an insurance component one way or the other. And so that is a large part of the reason. And again, the unfortunate part of that is in 2 years, a lot can happen. A plaintiff is essentially putting their life on hold. They're going to continue to obtain treatment. That means there's going to be updated medicals. Invariably, there will have to be updated expert reports. Nobody's going to go to trial with 2-year out-of-date reports. And so the costs continue to pile on from that view. So just jumping back to the beginning, in terms of cost effectiveness, in a nutshell, driving through to completion is one of the biggest elements in achieving efficiency, and that's one of the reasons that we take such steps to try to keep things moving along. So when your defense counsel is prodding or trying to seek instructions to move things along, that's one of the primary reasons. And of course, secondary to that is prejudgment interest is running as well. And that adds up in a very short period of time, particularly on matters, personal injury matters, where the rate is 5%. The pleading stage, I just wanted to touch base on that one because that is an element that is sometimes overlooked and rushed. We see a lot of plaintiff claims that are obviously boilerplate, obviously cut and paste. They have everything from spelling mistakes to claiming injuries that weren't present or alleging threshold in non-motor vehicle cases, that sort of thing. And it's unfortunate. It's a disservice to the clients. It's really important for us to spend time on a pleading and to not use a boilerplate content in order to tell the story. And the reason is simple. Again, when it goes to trial, the only documents the judge are going to read before the trial begins are the pleadings. And if you don't set out your story concisely but accurately, then usually the only person that has bothered to set out a story at all is the plaintiff. So it is an important stage, and that's why the gathering information stage is important as well. And we try to be as thorough as possible because the better work done up front, in the long run, the more efficient the action is going to be litigated throughout.
So there are two kind of different kind of sections of civil actions, and they're really based on the monetary value of the claim. So the first is simplified procedure. Right now there is a limit of $100,000, so any actions under $100,000 should go into simplified procedure. At the litigation conference that we've attended a few weeks ago, we were advised that the Rules Committee will be changing that in the near future to $200,000. So that will be putting more actions in the simplified procedure realm with the hopes of decreasing these lengthy, these proceedings that are going years upon years and hopefully reducing some of the costs. The reason being, in simplified procedure, it's a 2-hour examination for discovery. Each party has 2 hours to examine the other parties, in contrast to the 7 hours of examination for discovery you get in the under the regular rules. One of the other changes that are coming down the pipes for the simplified procedure is that there will no longer be jury trials. And again, I think this is in the hopes of clearing up the backlog and, again, decreasing the costs associated with these types of actions. There's also a summary trial available in simplified procedure, which I think allows the process to be expedited.
I'll jump in on that. I'm going
Sure.
to be running a summary trial next week, and it's scheduled for 4 days. And so what a summary trial means under the rules of simplified procedure, it can be ordered if the case is brought in simplified procedure, or in our case, where the action was commenced outside of the rules of simplified procedure, but it has become obvious to all of the parties that the damages are under $100,000 or close to it. Summary trial means that the evidence in chief is provided by way of affidavit rather than examining somebody in chief from the stand. So that saves a lot of time. Under the usual rules for summary trial, an examination in chief can last no more than 10 minutes for any individual who's provided an affidavit. And you're not required to bring all of the affiants to trial. If a party wants to cross-examine on any of the affidavits, they must serve a notice of intent to cross-examine 10 days or more before trial. And if they haven't served that notice, then they have no right of trial. So again, that helps expedite things. In our case, we had affidavits from no less than a dozen witnesses on one side, and we have elected to cross-examine less than half of those at trial because either the evidence is redundant or is blatant hearsay and doesn't really require cross-examination to prove that. So that's a really effective tool in terms of reducing the time spent in the courtroom, but it also helps eliminate a lot of time for preparation because we know what the evidence in chief is going to be going into trial, and we can tailor the evidence in chief that we want our witnesses to give based on what's already been disclosed or we know will be disclosed to the court through the affidavits. The elimination of the juries for $200,000 or less, I think is not a good thing. In our experience, you never really know what you're going to get with a jury, but in the long run, they tend to inject an element of common sense. I know that's not the popular opinion among the bench, at least. I'm familiar with the Mandel versus Fakim decision of earlier this year. That was a decision in which the judge said that jury trials in civil cases seem to exist in Ontario solely to keep damages awards low in the interest of insurance companies. And that was a motor vehicle accident case in which a jury awarded an individual $3,000 for general damages, which of course means after the deductible he got nothing. And I tend to disagree. I admit I have a slight bias, but at the same time I think that there is an opportunity to presume an element of fairness among the jury, and the fact that these are individuals that have had a variety of experiences in their own life. So I think that you're going to see two things, unfortunately, is right now claims where individuals could probably bring their matter in a regular superior court action if they know they're essentially dealing with a general damages claim with no loss of income or a very small loss of income or competitive advantage. I don't think I'm going to be surprised to see a lot of personal injury actions in particular being commenced in the new simplified procedure rules under $200,000 for the simple fact that they will obviate a jury. And I say that because right now I'm involved in a lot of actions. We do a lot of municipal defense work, and there's an increasing number of cases where the municipalities are brought in, even on the flimsiest of legal propositions, and it appears that oftentimes the sole purpose is to displace a jury because juries aren't allowed where a municipality or the Crown has been named. And as one mediator put it to us at an action, even where it appeared there was no liability to us, he said, "You're never going to get out of this action because without you, we go to trial with no jury, and the plaintiff won't have to worry about paying your costs because the at-fault defendant will have to pay those." So that, I think in the long run, that will be a net. Obviously the question is how do we turn it to our advantage? The upside of that is increased efficiency. Because right now, and I think often, examinations are part of the most expensive and time-intensive part of the process. There's a lot of time to review the documents, time to prepare the witnesses, attending the examinations themselves, and then reporting after it. And that's something that you guys have an opportunity to control with respect to the reports. I think it's important early on in the process, but even prior to examinations, to have a discussion with counsel about how much detail you need or want from the examinations. If you're familiar with the case, maybe you just want a summary of the evidence pertaining to liability or pertaining to damages, or maybe you just want to report on an assessment of damages, knowing that you can get the information, the underlying information afterwards. In some cases, we'll receive instructions to order a transcript right away, provide the transcript along with a brief comment on liability and damages. Oftentimes, though, if the examination goes more than one day, the transcript might be a bit unwieldy. So it's really up to you how much detail you want, and that, of course, might be driven by corporate policies as well. But that is an element that can also be controlled to some extent and also help drive some efficiency in the litigation.
Yeah, so let's move on to the next slide. So we have another question for everyone to answer. After litigation has started, what steps do you take to achieve early resolution? We have a few options here for you.
All right. Thank you, Jennifer. I will launch this poll.
So some of the options we've said, attend examinations. I think that one's really cost effective to get a sense and a flavor of the file. See what the evidence will be. You also credibility of the insured and the plaintiff, which I think is really difficult to capture letter after examinations for discovery. You know, especially when it's your own insured, you can get a sense of whether this case should be, you know, settled or not. So I think it's very effective for the adjusters to participate in that.
Not a lot of answers or huge response under other right now, and I think in retrospect we should have included some more details. One of the things that we've been using with increasing success and frequency is case management. We're fortunate in Ottawa to have 2 masters on staff. And case management is a process under the rules that allows us to effectively have a master assigned to preside over the fast tracking of an action. So if you can think of matters where a party is languishing in getting undertakings or is just not getting back to counsel with respect to scheduling, everything from the outset, examinations, discoveries, documentary exchange, that sort of thing. The case management approach allows us, without costs, except for the cost of attending, but to achieve a timetable that in the old days we used to have to do by way of motion.
All right, I think most people have had a chance to answer the question, so let's close that poll and share the results.
Bit some diversity here. So 64% attending examinations, which I think is really a good approach to be taking. It's, like I said, gives the adjuster the flavor of the case. Thorough investigation of the plaintiff, 46%. I think that's also essential. And it's definitely something that the adjusters can do at an early stage now with social media, doing a quick Google search, even before we get the file. You can find some excellent information on there. And I know we've had cases where there was one I worked on where the plaintiff said she was in a band and she couldn't play the guitar anymore, so she couldn't make any money. You know, after some Googling and some Facebooking, we saw her playing guitar on multiple occasions after the date of loss. So these are easy things that can be done at the outset.
The effective use of Rule 49 offers, for those who might not have used them as much, this means an offer compliant with Rule 49 of the Rules of Civil Procedure, which sets out what the offer must contain in terms of clarity of what's being offered for general damages, special damages, interest, legal fees, etc. Obviously, if the number is 0, then that's pretty simple. But the effect of Rule 49 offers is sometimes tremendous. Depending on the timing of it, it has cost consequences. And if the plaintiff is unable to beat the offer that you make, then the recovery, even if they're successful at trial, is going to be limited. And it's possible for the defendants to achieve recovery of costs. And in some cases, those costs can even outweigh those of the plaintiff.
So we can just move on.
All right, let's get back.
So we touched on mediation in the last question, and that's what we're going to address now, is what comes first, mediation or discovery. And mediation before discovery can often be not only very effective, but rather an obvious choice, particularly in subrogated actions. We're going to touch on those in a matter of moments, but with respect to property damage, personal injury, any case where the facts really aren't in dispute, and ideally where liability isn't really seriously being contested, or at least where there's a relatively narrow band of liability to go around, then a mediation before discovery can be very efficient. As I mentioned, the discovery can often be the most expensive up to preparing for trial part of litigation. And so using mediation, or the opportunity to have a mediation before discovery, can often, if it's not even successful, at least narrow the issues. And the parties can come to an agreement on what needs to be explored in the rest of the process. But it is often very successful, and particularly in cases where the facts are obvious, or at least not seriously contested. Now, the other element of it with respect to the online investigations that Jennifer mentioned a moment ago is surveillance. Just because you're going to mediation before examinations doesn't mean you can't obtain expert reports or surveillance, that sort of thing. Surveillance is something that's becoming increasingly under fire. There was a recent decision here in Ottawa in March of this year, the Nemchin decision. And in that matter, Justice Cawthorn came down quite hard on the surveillance to the point that it wasn't even allowed to be admitted at all. And there were a couple of reasons why, but the two primary drivers were, first of all, the video that had been presented was edited. And the plaintiff's counsel successfully argued that the editing of the video did not allow the jury to see the totality of the plaintiff's experience. in what she was doing, what she was observed to be doing. And the secondary problematic aspect of the report itself was that the investigator had made comments which the judge found the investigator was not qualified to make. So even a comment that appeared as innocuous as she was walking with a normal gait or appeared to be walking pain-free, that sort of thing, the investigator had no expertise on which to base that observation, and the report itself and the observations of the investigator were found to be weightless. And that's something to consider when ordering surveillance. And we do have some guidelines that we send out to our clients when we recommend surveillance or if we're obtaining surveillance that we like to see observed by the investigators in an effort to try and make this admissible or at least reliable if we're going to try to persuade the plaintiff and the plaintiff's counsel. And keep in mind, we like to give the plaintiff's counsel the benefit of the doubt. Our experience typically is that they are going to believe the story that their client tells them, and they're going to give their client the benefit of the doubt. So a lot of times, if we obtain surprising surveillance, it's sometimes just as surprising to the plaintiff's counsel as it is to the plaintiff that we were able to obtain it.
Just before we move on, just with respect to the mediation versus discovery, when you're in any mediation, even if it's after examinations for discovery, something to reduce costs is looking at the mediator. Mediation fees can be pretty costly for the mediator themselves, and it really varies depending on the expertise of that mediator. So if this is an action where both parties are fairly close or it's pretty straightforward, you know, there's a roster of mediators that are used which tend to have cheaper rates. Maybe something to consider to look at that roster and pick someone off the roster to keep costs down, as opposed to, you know, picking someone with a bit, you know, the more expertise and who's more, I guess, in demand per se. So that's just a way to consider it. So do your research and find a mediator that you think is appropriate and will be the most cost effective for you.
And last point, with respect to the online investigations, again, we can't underscore the importance of these enough, because a lot of times the plaintiff's counsel will advise their clients to wipe clean or delete altogether their accounts. And to the extent that you're engaged in discussions with these individuals before litigation commences, you might have a narrow window to access these accounts that won't be open to us. And so anything you can get at that time is helpful. For two reasons. Number one is we can put it to them at examinations. Even if someone's Facebook, Instagram account has been deleted, we can put it to them and ask them if that account existed and ask them to preserve it. Because, of course, Facebook accounts in particular, they don't get deleted. They're always there. They can be reactivated. And there is case law indicating it's appropriate to have them reactivated and some of the content available provided is relevant. That goes for Twitter as well. We just recently completed a motion for security for cost, in which we relied quite heavily on the individual's Twitter and Instagram content due to the sheer volume of photographs that were uploaded and that depicted the appropriate part of the person's body that was at issue in the action. And the second element of that is the admissibility of any evidence. So keep in mind that if you are the source of the information and someone has deleted an account, it is possible down the road, as it is for a variety of reasons in civil litigation, that you yourself could be called as a witness to testify as to what you've seen. That happens often in motor vehicle cases where we take a position off coverage and have the insurer added as a statutory third party. The plaintiff's counsel is still entitled to an examination, and the case law tightly circumscribes what can be covered. But to the extent that any relevant information and evidence has been adduced that is no longer available, that is certainly something that would come up. So if you find something particularly juicy, there are some investigative agencies and some independent agencies that have added this competency to the suite of services that they offer, and it can be worthwhile to engage them for this information as well. For the same reason we retain private individuals for surveillance, is because those individuals themselves might be the ideal experts to be able to testify at trial if necessary.
All right, so Sean just talked about this, consider when to engage experts. You know, one of the big things about using experts is using them creatively. I know Sean and I were talking about a few ways to that. Maybe Sean can talk about that.
So we just had a PowerPoint issue here.
There's the technology letting you down.
So again, in terms of the creative use, keep in mind, just because you hire an expert doesn't mean they need to create a report or a paper trail. In fact, sometimes you may not necessarily want one, because once a document is created, we do have to disclose it. And whether we disclose it in Schedule A or in Schedule B meaning that we're claiming litigation privilege in it and we're not going to be reducing or producing it or relying upon it, it does disclose to the other side. And you can imagine in cases we would take the same view. If someone has an expert report and they put it in their Schedule B and they're not producing it, 9 times out of 10 you could probably guess that report's not very helpful. So what we do, and what we know the plaintiff side will do as well, is retain an expert. Sometimes they would be willing to do the investigation and provide a verbal report. And upon the receipt of that verbal report, you can decide whether or not you want to proceed to the next stage of a written report and potentially rely on that expert at trial, or engage heavily in settlement discussions. And we've had that happen. I'm sure many of you have had that happen as well. Sometimes it's worth knowing early on in an action if an expert is going to come back and say, liability is going to be pinned on your client and here's why. You need to know that, and frankly the sooner you know it the better.
Moving on to offers to settle, there's 2 types. Sean talked about Rule 49 offers, but I'd like to talk a bit about the time-limited offers. It's something that I'm using right now in a file, so very fresh in my mind. Time-limited offers essentially are when you're putting a time limit on when it can be accepted. The case I'm using this for is to move the matter along when documents were waiting for productions and they haven't done so. And quite frankly, I don't think there are any productions, so it's a bit of a stall tactic. They've asked for a few extensions on time on producing the documents because we have a court order with respect to that. So I think it can be a useful tool to move the matter along and provide them with that option. Say, look, you know, I don't have any documents, so here's my offer, and it will expire, you know, by X date. And in my case, it happens to be just a dismissal, but you know, some other offer, and it can be done as well. So I think that's useful too in that regard.
Just one final point on experts, and this is something that has certainly been on the radar screen in Ottawa for the last year, is you really want to carefully consider who you're retaining. A lot of times there's default lists of preferred vendors, that sort of thing, depending on the field. And what we try to do is a bit of an investigation up front if it's an individual that's not familiar to us. Again, recent Ottawa cases have come down quite hard on one expert in particular. There was an expert who was retained and testified at trial last year, and the judge on a threshold motion blasted him, frankly, focused on the fact that this gentleman exclusively performed defense side medical opinions, had a virtually non-existent clinical practice, and didn't draw upon significant recent experience in the field on which he was testifying. And that sort of analysis is just devastating to the expert's testimony when you're trying to persuade a judge that they should rely on that individual. There are quite a few providers out there that will perform both plaintiff and defendant analysis and reports, and these individuals are relatively easy to find in the reported decisions that we can find on Canley or Web. Do some research on them, and you really want to make sure you're using an expert that at the very least their evidence has been accepted either by the court or tribunal. A lot of times in the WSIB tribunals across the country or disability matters, that sort of thing, that's where we see a lot of the health experts in particular engaged. If it's a actuariist, accountant, someone performing any sort of financial analysis, you really want to look into their background and understand whether or not they've been recently relied upon and whether or not their evidence has been found to be reasonable by a judge, or at the very least make sure they haven't been blasted by a court recently, because you can guarantee that the judges are going to do that sort of a homework now.
Definitely. Okay, so we'll touch now on just the types of files that we're usually getting from you guys, mainly defense files and subrogation files.
So on a defense file, sometimes the very first question that might pop up is whether or not you need a coverage opinion. And that is going to be fact specific, of course, and depends on the type of case, but it ranging everywhere from motor vehicle accidents where an illegal act has been implicated to whether or not a particular property loss claim may fall outside of coverage. The reason we put this up here first is because a coverage opinion necessarily must be separate from a defense opinion. And it needs to be first because if there's an opportunity for taking an off-coverage opinion or at least a non-waiver position, that is the sort of thing that can be waived by conduct. And the Ontario case law supports the insured's right to rely upon the representations made by the insurer, and that includes if if it's a completely unfettered defense that is offered, and down the road, grounds that were known to the insurer are tried to be relied upon in an attempt to limit exposure or limit coverage, the Ontario courts say that that's just not going to fly. In a nutshell, if there is an opportunity up front, the insured needs to know up front. There is an obligation of good faith, and the courts will enforce it. And for the coverage opinion, it does happen sometimes that we're retained and a coverage issue pops up after the fact, and that's fine. The timing certainly cannot always be controlled. Just keep in mind it needs to be another counsel. We would be in a conflict to provide both a defense and a coverage opinion.
Okay. So think about defense files, anything in any file really, subrogation or otherwise. If you think a party is responsible, put them on notice. There's no harm in putting someone on notice, even if you don't end up bringing them in at a later date. It allows them to conduct their own investigation, and I think sometimes it can even, once they do conduct their investigation, they can maybe determine that it's not them, but it's somebody else, and then that puts you on notice of someone else you may want to name. So there's really no harm in doing that from the outset without counsel being involved, and it will be helpful to us to kind of establish who the parties are if we're doing a subrogated claim or bringing someone in by way of third party. So that's definitely something that we would recommend.
Another element is, along with the file information that's sent to us at the outset of a file, is sending the contact information for the insured, including emails, telephone numbers, cell phone numbers, anything you know, because sometimes numbers change, people move, and if we've only got one way of contacting an individual, then and I've had this experience, I'm sure you have too, where you can spend a lot of time trying to track somebody down if you don't know where they are or what's come of them. So that helps. And then the other thing is, it really helps us a lot if you tell the insured that someone from our firm is going to be calling. Because keep in mind, for a lot of individuals getting sued, this might be the only time in their life they've been implicated in a lawsuit. They're going to be on guard, and understandably so. And so when we call out of the blue and say, hey, we're a lawyer and we're representing you in this action, I've had experiences where people may not necessarily believe us, and they want us, not only they don't want to hear it from you necessarily, they want to hear it from their broker. So it goes a long way towards I guess, a more efficient and a fast-tracked initial discussion, because I'll tell you, I like to speak with the insured before I draft my defense. I always want to speak with them and understand their side of the story and any relevant information that they might have to the claim or to the defense, and a lot of times, and in fact most of the time, I'd say it is very helpful. So just those little things, like letting them know either by way of email or phone call that somebody from our firm, and if you know who, if you know the lawyer's name, that's even better, is going to be calling you, and it's okay to talk to them because they're acting in your interest. I'm going to give them the same spiel when I talk to them, but it opens the door towards that discussion. And then again, also, we need to be transparent. If there are any coverage or waiver issues, then I will address those as well. It's not appropriate for me to raise them, but if they've been raised by the insurer, then we'll certainly address those. And again, better earlier than later, because in some cases, they may be entitled, and in fact, it might be better than not for them to have independent counsel, depending on the situation. And if that's the case, then I want to coordinate with that counsel as well.
Definitely. And just the last bullet point, which we've kind of stressed, is send us everything. Even if something you may not find relevant, we may find relevant to the case. So from the outset, I would provide everything in the file, and it's really helpful to do that.
Now on to our third survey question. When do you typically retain counsel for subrogation? We've got a couple of choices here, 3 choices. Number 1, immediately, or soon after the claim is opened. Number 2, weeks or months before the prescription period expires. And number 3, the day the prescription period expires.
I'm seeing immediately, which is nice. A lot of weeks and months. No one the day of the prescription period expires. Unfortunately, I have received a few.
Nobody's going to admit
so
that.
Someone is out there sending these, which sometimes, again, you can't control these things, but we, of course, would always recommend as soon as possible.
All right. Thank you very much, everyone who's participated. Most of you have now answered let's close that and share the results.
So weeks or months before the prescription period expires, 58%. So I mean, that's majority, although, you know, the close second is immediately or soon after the claim is opened, which 42%, I commend the 42% who do that. In my experience on subrogation claims, I've received them weeks before the limitation period, if not days, which can lead to, I think, mistakes when you're being rushed to do it. So and that will lead to additional increased costs, I think, down the road in terms of bringing motions, to having to amend pleadings, and all of that. So it's, I think, probably more proactive to think subrogation immediately when something comes through.
Yeah, I'm very happy to see no one in the camp of the day the period expires. A lot of time that happens in the week or the two before, and you know, there's a saying in civil litigation that is that as long as you don't miss a limitation period, just about everything is fixable. It may cost you some money, but it's fixable. Missing a limitation period that's the end of it. It's fatal. So it's really important to get those as soon as possible. Now, with respect to subrogation, we encourage you to think subrogation immediately for a variety of reasons. We're going to get into them specifically now. But also, if it's a question of liability, it's better to have an expert report sooner than later, because evidence is often perishable. A lot of times things get misplaced or stolen or just plain lost or damaged. And the sooner an expert is engaged to actually take a look at what is transpired, the higher likelihood of something being preserved. I'm going to examinations on a case on Friday where a key piece of evidence was examined by one party and then lost. And you can bet that the other defendants are all going to be claiming spoliation in that action, because now we don't have an opportunity to have an expert examine the evidence and challenge any of the conclusions or observations made by the other side. So it's really important when you're thinking of obtaining an expert report that you also think down the road, if you've got on-site storage or outside storage, or if you need to rent a storage locker to preserve it, keep that in mind as well. And
I think one other just point to add on that is, if you know who the parties are from the outset. I have a file right now, a product liability issue, and the adjuster on the file knew all the parties involved and all the companies who manufactured the various components of this product. He made the decision to invite those parties to the testing of the product, because it was going to be destructive testing. So he knew, had it been destroyed, everyone would have claimed spoliation. So that's a useful tool, and it's going to avoid that allegation down the road and all of their defenses. So it's definitely something to consider to reach out to their insurers, the manufacturer's insurers, or the manufacturers themselves, to give them that opportunity.
So the other element you want to obtain early on, if you can, is witness statements. And that goes for defense matters as well, but it's particularly important in subrogated matters, again, because people move on, people change jobs, memories fade, that sort of thing. And the sooner you can preserve a statement, the better. The closer an individual's memory is, or the closer to the event date at the time the statement is given, the higher the weight that is likely to be afforded that by a court down the road. And the next point is an important one in terms of organizing the file documents from the outset. And again, I know this is in large part driven by corporate policy and by available resources. It really makes a huge difference for us when we receive file documents that are organized into headings. And I don't mean to prescribe any. Everyone does it a little bit differently, but it really helps. So for example, we've received subrogated files where the file contents are broken down by correspondence internal, correspondence external, loss documentation. That could be everything from estimates to invoices, proofs of payment, that sort of thing, liability analysis, witness statements, whether it's in file folders, whether it's just in tabs, in a binder, or even with covering sheets and an elastic and a rubber band. That sort of organization really helps us drill through what are the important documents we need to review before we do our pleadings and organize the file ourselves. And it saves us a lot of time, or our clerks a lot of time, in organizing those files, because if we just get a big stack of paper or an electronic file with no semblance of order, we've got to go through each and every document just to make sure, first of all, we've got everything and all pages of a particular document, and then to in turn do the organization.
For the next point, determine the quantum of your damages in the subrogation claim. I think this is an important factor, and I think one thing to keep in mind is if it's a large file, like let's say an oil spill, I wouldn't be afraid to get a second opinion to make sure that the remediation work that you've had done or you're doing is the right way, because you for sure will be attacked on your quantum and what you've spent your money on. So just by way of an example, I worked on an oil spill, a fairly large one, where the remediation work was over $700,000. However, the property in which the oil spill took place was only worth $250,000. So you can imagine the defense counsel on those files saying, why did you remediate worth $700,000 when you could have just torn out the house or bought the house from the insured? So I think it's definitely something to spend time on and consider that you're making the right call. You always will be challenged on it, but at least if you're getting second opinions, it makes your case and your valuation of the damages stronger.
And on the last point, telling the insured the action will be subrogated, there's a few reasons for that, again, that go to the heart of the efficiency of the litigation for us. First and foremost is a lot of times the individuals may not be aware that a subrogated action will be brought in their name, and they might be surprised by that. So that's something that they should be aware of up front, is to understand what the word subrogation means, or at the very least that if there is an action pursued, it will be in their name. Secondly is these individuals often have information that is separate and apart from a corporation, for example, or a company that they work for. Particular events, it's not uncommon for people to use their personal cell phone or other device to take pictures. And if they know up front that there's an opportunity for this to proceed into legal proceedings, then they will preserve that. And we've got a higher likelihood of having that evidence if and when an action is initiated. And then lastly is any documents or things that they've created that they've kept personally or have in their possession outside of the company, or if it's an individual in the house, if they've got off the property. Again, the preservation of some of this information is invaluable down the road for us. So just knowing that the action may go into subrogation and what that could mean for them is of great benefit to us.
One more point on that. They can also claim, the insured has the right to claim any personal damage that they suffered that wasn't covered through insurance. So it may, be helpful for them to know what their rights are in a subrogated claim to do that.
And that's actually another good point for efficiency, is you may want to consider sometimes it's not uncommon for us to allow them to piggyback in our action. And I encourage you insurers to give some serious thought to that. You don't need to wait until the claim is actually complete before you initiate subrogation proceedings. And if it's not, you may want to, as I said, give some thought as to whether or not the insured piggybacks or commences their own action. And we've seen both. We've dealt with both. I've seen some where the obvious advantage to the insured is if they piggyback the main action, that most of the costs are going to be absorbed by us, because there's really no duplicated costs in representing them in the action as well. On the other hand, to the extent that that there is going to be evidentiary analysis that is separate and apart from this, they may be better off on their own. And in some cases, they might be better off pursuing their damages in the small claims court, where there's not going to be quite as much scrutiny or examinations or documentary discovery required.
So last point on this, send us everything. Again, we've kind of gone over this enough, but it's really important for us to see all of the documents, like Sean said, to make sure that we have all of the pages. So everything you have, we would like to have.
Yeah, and as I said, we begin with the end in mind, and I'll end where I began, which is a trial coming up next week, an action that's been proceeding for 7 years. We were brought into the action 4 years into it, and one of the counsel that was ordered by the court to compile a joint book of authorities declined to do so, and as a result we ended up doing it on our own, preparing it, sending it to the court and or to the other parties. And we got an immediate call back from one of the co-defendants who said that in 3 years of litigating this matter, they had no idea that one of these documents even existed because it hadn't been produced. And it came apart from one of the self-represented, I should say, one of the self-represented individuals in the action, to whom we just asked a simple question: would you happen to have a record of this? And they said yes, and sent it along. And who knows, the action or some part of the action may or may not turn on this, but it's just the sort of information that, or document, that everyone assumed was so obvious no one thought to look at or look to preserve. So sending everything to us can really help us from the outset. And as I said, beginning with a complete record of the information, the available evidence, prevents us from getting surprised, allows us to provide good recommendations with respect to whether to proceed to mediation or examinations, and also to provide accurate opinions, because our assessment of liability and damages is going to be derived exclusively from the information we have. And I think it's frustrating on both sides to have to provide an opinion that says, well, we really don't have a complete picture right now, so we can give you the best bet, or we'd have to presume the truth of what the plaintiff has pleaded, and we'll get back to you later once we have more information. So anything in your possession that could be sent is welcome, and anything that you gather in addition as litigation proceeds, don't presume that the insured is sending it to both you and us. If once an action is started, it's not uncommon, particularly in subrogated matters, for information to arise and be sent to one party and not to the other. In our experience, in particular, sometimes the insured individuals may not necessarily be savvy enough to realize they should be sending it to us too.
Fabulous. Thank you, Sean. Thank you, Jennifer.
No problem.
We will now see if anybody has any questions. We can reserve a bit of time for that. We have one quick question coming in. Well, we'll give people a bit of time to ask some of those questions. And I suppose my first question is, once a claims manager or adjuster has that material, are there things that they can do on an ongoing basis to, once the file is really in your hands, to keep the process moving?
I'd say one of the biggest things is following up, or, you know, I sometimes, as lawyers, we feel annoying having to, we always have to get instructions. So it's just helpful to have the adjuster engaged and prepared to give us those instructions. We're not asking because we don't want to, because we want to. We need them. So also setting, reminders perhaps in your calendars. If you haven't heard from the lawyer, every 30 days, what's going on, just to kind of get a sense of where it's at, and that will just keep the file moving along, and will keep the pressure on the lawyer to make sure that they're moving forward. That's definitely something I would recommend.
I think another aspect is sometimes we presume too much in that we presume, for example, an understanding of the law that is unfair for us to presume among a lot of parties. We act on instructions, and when we send letters or voicemails or emails requesting instructions, the reason we're doing that is because we must be instructed in order to take a step in the proceeding. And I think that's understandable. We're not entitled to substitute our judgment for your wishes. And as the adjuster managing the file, you really are in control. Now, it is our role to provide an assessment and a recommendation. But keep in mind that sometimes if you've got a difference of opinion or experience tells you something that you want to go against what we've recommended, that's fine. That's totally appropriate. But if we're pestering you for instructions via email or voicemail, it's not just to be a pest, and it's not just to make sure you're up to date. It's because we literally cannot proceed. We're okay to do so.
So a question we have here is, what is your opinion on summary judgment in the process? Which is funny because Sean and I were just speaking about this yesterday, and I said, we haven't really talked about this in the presentation, but sadly the courts recently have not been in favor of summary judgment, which is unfortunate for defense counsel because sometimes that is the most cost-effective way to go. A recent decision in Ontario has kind of the court has put their foot down on partial summary judgment motions. So if you have an issue where damages you're willing to agree to and you're consenting to the damage, quantum of damages, is an issue, courts have kind of said it's a waste of time, and why not just wait till the trial to deal with all of the issues. I don't know if you have anything else to add on that, Sean.
No, frankly, it's been frustrating, simply because after the Rainey Act decision came out, we were encouraged, and we proceeded with motions for summary judgment in a few actions where we thought we had a high degree or likelihood of success. In one we were. Here's what I would say. If you've got a case that can be fairly heard exclusively on documentary evidence, on paper records, then absolutely bring a motion for summary judgment. Otherwise, it is likely going to be punted to the trial. And the case that comes to mind was out of Toronto just a couple of years ago, where a minivan popped a flat tire driving along Jane Street and pulled over on the right side of the road, which happened to be a live lane of traffic. She pulled over safely. The car behind her pulled over safely. The third car in line rear-ended the second car, which in turn hit the first car. So the first car commenced a lawsuit against the second car. Second car commenced a lawsuit against the third car. That party third-partied the van's driver who popped a flat tire, said you shouldn't have pulled over. And that car's insurer brought a motion for summary judgment saying it's obvious she had to pull over, she had a flat tire, dismisses third-party claim. And the judge refused to do so. They said, no, that's a matter for trial because the defendant driver had raised the possibility of, hey, maybe you could have made it a few hundred meters on the road driving safely with a flat, or maybe you could have pulled off on a side street a couple hundred meters up or into someone's driveway or who knows what. So it appears to be a clear-cut case, but again, this is something that's going to be conflicted on the personal testimony of what was reasonable in that circumstance. The one case we had success with was exactly that. It was a document-driven case. It was a case where signed contracts were ultimately going to be what needed to be interpreted and applied in the action, and the judge was prepared to do so. So for all of those reasons and the reasons Jennifer mentioned, I'd say unless you've got a case that can be determined on documents, the indication we've seen from the Ottawa courts is it's not likely going to be decided favorably in the motion.
We have just one inquiry about getting a copy of this presentation. You should be able to get it from the dialog box on your screen where under handouts. You should be able to download it from there. But if by chance that's not working for you, just drop me an email responding to the invitation that you received with the link for this webinar should work fine. And I think we have probably time for one more question, which has come in about consumer protection. I'll turn that over to Sean.
Sure. The question is Consumer Protection Act versus occupiers liability. Which one of these is more difficult to defend and why? Well, I could spend all day talking about that. I think
that's next week's webinar.
Yeah. In a nutshell, the Occupiers Liability Act case law on point, and there's more experience both on the part of the bench and part of I think the common sense element being the jury with respect to what the Act provides for. And I'm thinking specifically of sections 3, 4, and 6. Occupiers liability being it's not required to be perfect, it's required to be reasonable in the circumstance. That section 4, there are circumstances where people voluntarily and willingly assume certain risks. And section 6 being that if you contract to a competent individual to perform a role of an occupier, that you can rely on that contract as a displacement, so to speak, of the liability and shifting of the liability. The Consumer Protection Act, there actually is a recent case, and if you're interested in this, I'll give you the citation. I think this just came out last week. It's 2017 ONSC, as in Ontario Superior Court, 6903. It's available on Canley, and it's Park Hill Excavating versus Robert E. Young Construction Limited. This is a case where Robert Young Construction had supplied septic sand for a subdivision where some 30 homes were built with equipment provided by that company and had experienced some issues due to deficiencies in that. And what I think is interesting about this case is the judge found liability under Section 15 of the Consumer Protection Act, the Sale of Goods Act, and that's the section that provides for an implied warranty. They specifically found no liability for negligence, and the reason was they found that there was no evidence as to the standard of care applicable in the circumstance, and they would have required expert evidence with respect to the standard. In the Sale of Goods Act and the Consumer Protection Act, what is unique about them, as I said, on the one hand, they have not got a tremendous amount of litigation. When you look at the Sale of Goods Act, for example, perhaps not surprisingly, you'll find a disproportionate number of cases typically dealing with the tank and the implied warranty on the fitness versus pit erosion. On the Consumer Protection Act, it is very heavily consumer favored, as it should be, and that is the point of it. But the dearth of case law also makes it open to the court to substitute their own reason for reasoned decisions or for case law that has interpreted it. And for that reason and the relative lack of sophistication on the parties that are the circumstances typically invoke it, there's less I should say fewer tools for us with respect to both the cases, the judicial authorities, and extra provincial authorities wheel before the court to apply for similar circumstances. So for that reason, I'd have to side on that one with the Occupiers Liability Act as being relatively more useful tool to defend against.
So just, I guess that concludes our webinar. You know, although we may not be retained by everyone here, we're happy to answer any questions that you have. Doesn't matter if we have a file with you, anything you need, give us a call and we'd be happy to chat.
Thank you very much, Sean and Jennifer, and thank you everyone for spending your lunch hour with us. We have here a couple of you're in the Ottawa area. Members of the insurance group will be presenting at the Insurance Institute presentation in early February, which will be a summary of some of the major case law decisions from 2017, which will impact insurers. Many of those case law can be found in our risk report, Rulings Insurers Should Know, which can be found on our website and comes out 3 to 4 times a year, and you can subscribe to that newsletter online. And we'll have another webinar later in February or early March that also addresses some of the top cases from 2017. We've hit 1 o'clock, which is our signal to say goodbye, and thank you very much, and wish you the best of days.